Hi, I'm Erica Cicero from e.cicerolaw LLC with your estate planning made easy moment of the week. This week I want to explore what happens when someone has a degenerative mental condition such as dementia and that person does not have a will or a trust. First, let's go to the Louisiana Civil Code to explore some key terms that we need to understand before we dive too deep into the topic. According to the Louisiana Civil Code, Article 1477, to have capacity to make a donation, a person must also be able to comprehend generally the nature and consequences of the disposition he is making. This is frequently referred to as the sound mind test. There is no basic level of intelligence or some kind of IQ test that is used to establish sound mind. Therefore, no one can argue that a person was simply not smart enough due to some kind of special needs. As long as that person is able to comprehend generally the nature and consequence of the disposition that he is making, then he appears to fall within the legal definition of capacity. But returning to the definition, what does nature and consequence of the disposition he is making mean in layman's terms? Basically, in the most general sense, can the person establishing a will understand what he has and what he wants to do with it? So even though Dad may have dementia, does he understand what his property includes? Does he know what he wants to do with it? Dad doesn't need to be so intelligent that he understands the entirety of the will he's executing. He may not understand the complicated legalese, but as long as he clearly understands that he wants his farm in Folsom to go to his eldest child, we'll say, then according to the most basic definition, he has capacity to do that. Just because someone is elderly and perhaps suffering from an ailment of the mind does not mean that if his will is challenged, then it'll be thrown out for the testator lacking capacity. Since people are living so long these days, more frequently assisted by medication that can alter a person's mental state and perhaps their capacity, it's becoming increasingly more likely that challenges to capacity will be heard by Louisiana courts. Therefore, the courts have begun to establish that illness, particularly prolonged illnesses due to age, do not negate the person's capacity and do not automatically make Dad incapable of leaving his farm to his eldest child. However, if the party challenging the will can establish outrageous behavior, long periods of sedation, and other factors such as undue influence, then the court can throw out the document and the estate will fall into intestacy when someone dies without a will, and the Louisiana law controls the devolution of the property. Linked below, I will link all of the different videos that I've talked about intestacy and what that looks like. Each situation is unique, however, and the estate planner will have the responsibility to take certain extra precautions to ascertain that his or her client is legally of sound mind. As I mentioned earlier, there's also the issue of undue influence that is another major cause for challenge in estates in Louisiana and all over the country. Let's go back to the Louisiana Code to explore this more. According to the Louisiana Civil Code, Article 1483, a person who challenges a donation because of fraud, duress, or undue influence must prove it by clear and convincing evidence. However, if at the time the donation was made or the testator executed, a relationship of confidence existed between the donor and the wrongdoer was not then related to the donor by affinity, blood, or adoption, the person who challenges the donation need not prove the fraud, duress, or undue influence by a preponderance of the evidence. Whew, it's a lot of legalese. Let me break this down for you in an example that is unfortunate, but many of us have heard before. So let's go back to Dad and his farm in Folsom. So he has his farm in Folsom and a lot of money. He has one child who shows particular attention to him in his old age. This child, we'll call her Karen, decides to start telling Dad things about her siblings, things that are definitely not true, things that hurt her father, who is well into his 90s and sometimes gets confused. Because Karen has lied to her dad, he believes she has taken such good care of him. He listens to her when she encourages him to change his will and leave her everything, and not her allegedly hateful, evil siblings, who will now receive nothing. Whereas before, all the siblings were to divide the property equally. In this example, Karen's siblings may have an argument under the Louisiana Civil Code 1843 that Karen unduly influenced her father, and he therefore lacked capacity. Therefore, if the court does accept the siblings' argument that Karen had undue influence over their father, the will can be tossed out, and Dad's property will devolve in intestacy. Since she is a blood relative, the siblings will have to prove this by clear and convincing evidence, which is a significantly heightened standard. Because 68% of people die without having a will, it is statistically more likely that a person with a debilitating mental condition, such as dementia, will not have his or her affairs in order when the disease begins to strike. However, this does not mean that the person is incapable, unable to create an estate plan that is entirely valid, as long as the person is of sound mind under Louisiana law. A good estate planner, such as myself, can help you ascertain that yourself or your loved one is of sound mind, and that the estate plan, a will or a trust, will hold up if it's challenged in court. If you're interested in creating an estate plan so that you don't have to worry about not having a will or a trust in the event of mental incapacity, please contact my office. My contact information is listed below. If you haven't done so already, please like and subscribe for more weekly videos like this.